Hello, my name is Mark Watts. I'm a partner here at Bristows at the IT and Data Protection Group. In this video, I thought I would talk to you about some of the reasons why an organisation should want to put in place a compliance program in relation to data protection, and then also some of the perhaps key considerations or ways of going about achieving that. So, kicking off, there are many reasons why an organisation should start to take data protection seriously if it's not already doing so, and perhaps top of the list, maybe second and third on the list, would be in order to protect its reputation. So there are still organisations out there that have suffered a fairly significant data breach over the years that's attracted an awful lot of adverse publicity, and it's still the case that perhaps many years later their name is still being linked to that incident with the brand damage that may come with that. The other reason, of course, is because in many countries it's the law, and non-compliance might be met by some form of regulatory enforcement, whether it's the processing concern being prevented by the authority, or the imposition of a fine, or any number of things. Regulatory considerations would also be fairly top of the list of reasons why to think about complying. We see increasingly data protection compliance just forming another component of a broader compliance agenda generally. So for larger multinationals, particularly those parented in the US, we see a big focus on compliance, the establishment of compliance departments, compliance functions, and data privacy is often just one of the many components of compliance of a whole variety of laws that may be relevant to that organisation. One of the other things that we see from time to time is that when an organisation tries to do something new, whether it's bring a new product to market or roll out a new IT system or HR system or whatever it might be, thinking about how to comply and getting the compliance right at the outset can avoid an awful lot of pain and suffering and business disruption further down the road, avoiding somebody trying to implement either a system or a project or whatever it might be in a country where there are some legal challenges to that perhaps haven't been thought through early enough. Other reasons would include, we see as organizations try and globalize and harmonize their processes, it follows that a lot of their processing of personal data also needs to track that, and they maybe want to centralize their systems or harmonize the way they do business across various divisions or companies or whatever it might be. And that move to harmonization often has significant impacts for how personal data is handled. And it's just much easier to get a grip on some of that if it's thought through in the context of a broader compliance program. Occasionally, not always, but occasionally, depending on the type of business that the multinational is in, we also see multinationals seeking to gain some kind of competitive advantage based on their privacy compliance, or putting it another way, based on the level of trust that they think they can perhaps increase from users by being seen as a safe pair of hands in relation to information about those users. So it's certainly the case that an organisation that's widely regarded as perhaps having sloppy practices or losing data or not handling credit card information appropriately or whatever it might be is not going to be an organisation that individuals are going to be keen to put their trust in when it comes to their information. One of the other drivers that we see, if we look at this particularly with a European pair of eyes, is there are some pretty well publicised restrictions on moving personal data out of the EU, whether that's to the US or to offshore processing to India or wherever it might be. And a number of the solutions to that issue, to that export ban, come in the form of a compliance program. So one of the most well known for at least US organizations is the possibility of the multinational entering into the US safe harbor on the Department of Commerce website. But to do so, that isn't merely, or at least shouldn't be merely, a box ticking exercise. That should be something that's carefully considered and done on the back of implementing a privacy policy, having a proper audit regime, training staff, and so on. In other words, putting in place a compliance program. And equally, we see very similar considerations for those organizations who, again, motivated by solving the data transfers problem, go down a different route, perhaps, say, looking at binding corporate rules, which is essentially a form of data protection compliance program. So what might that look like? And they all, they come in all sorts of different shapes and sizes, and there isn't, and nor should there be, a one-size-fits-all approach to this, because if it's going to be a really effective program, then it needs to be something that is tailored and specific and appropriate for the organization, both the nature of its business, the size of the organization, the geographical spread of the organization, whatever it is. Compliance programs, while they have similarities, they do all tend to be somewhat different in some respects. Now, to the extent one can draw various themes out of all of this, then one way that we sometimes talk about a data protection compliance program is to distinguish between what we sometimes refer to as the paper elements, the paperwork, the practical elements, by which we mean the way in which we influence how the organization actually handles its data, and then also the people elements. So paper, practical, people would be one way of categorizing things. When it comes to the paperwork, unfortunately there's no shortage of paperwork when it comes to EU data protection compliance, and the most well-known and in some ways burdensome aspect of that is the whole process of completing notifications and seeking authorizations from various data protection authorities. So it is, at least for the time being, a legal requirement. That may change, but right now it is. And organizations shouldn't ignore it. And what they ought to do is incorporate into their compliance program some assessment of how best to go about notifying what could be many, many systems in many, many different countries. And essentially what we would try and build into any form of compliance program is an attempt to prioritize, to make sure that the most important systems are notified in the most significant countries for that business. But that certainly ought to form part of such a compliance program. Also on the paperwork side would be one of the available solutions to the data transfers issue, which is the implementation of EU model clauses. Now, not everybody implements model clauses, but many organizations do. And if they're being used, this itself can be a fairly significant undertaking, because there's quite a bit of paperwork involved. There's potentially hundreds, if not thousands, if not tens of thousands of contracts involved that need to be signed up potentially around the group with all the different subsidiaries executing the contracts to cover off the various data transfers. So that can be quite a paper-heavy exercise. Again, for the other solutions, for a binding corporate rules solution, there's some paperwork in that. There's an application form that needs to be filled out. Equally, if you go down the safe harbor route, there's the interaction with the Department of Commerce website in the US. There's various other bits of paperwork that need to be conducted. And it may be that in certain cases and for certain types of processing, there's also a need to perform things like privacy impact assessments, say if you're doing extensive employee monitoring or something similar. So think of it as a work stream, if you like, to get on top of the paperwork. That needs to be incorporated. Now, the other aspect, which in so many ways is more important, goes to influencing how the organization itself actually handles the personal data. So what does it actually do in practice? Now, a lot of what it does in practice and what it should do in practice will also be written down. So there's paper involved. But the focus of this type of paperwork is not so much meeting explicit regulatory requirements, but rather modifying and controlling how the organization itself handles information. So if you like, it sets out the do's and don'ts. And the classic way of doing that would be to have some form of data protection policy. And typically what we see then is beneath that policy there'll be another layer, perhaps two, perhaps even three layers of documentation going into increasing amounts of detail and specificity about certain types of processing. So we'll see a policy, and then beneath it perhaps procedures or guidelines or whatever those documents tend to call themselves, but ultimately a set of documents that are setting out the rules of the road internally within the organisation for how its staff should handle personal data. And then finally, and frankly it could go in on the paper side or the practical side, but to the extent there's any outsourcing involved, engaging data processors and so on, there may be some standard contract templates or clauses that need to be used to impose security obligations and so on. But essentially to influence how that third-party processor handles your data for you as a controller. And then the last element of this, what I call the people side, it can be overlooked because in some ways it's the most obviously expensive, in the sense that if you take on more people, then you increase headcount, there's a cost associated with that. But it's terribly important that if the program is going to be not just built but also lived with and maintained over time, then a significant amount of thought needs to be given to, well, who are the people who day to day are going to be policing the policy, who are going to be the people that other people go to when they have a query, who's going to do the training, how are they going to be trained. And then equally on the other sort of people side, there's an audit requirement here, so you also need a body of people internally just to keep an eye on what the organisation is doing and to what extent it's living with its commitment in the form of its written policies. So looking at the question now of how an organisation makes all this happen, it may be helpful to just think about it in terms of, well, who should be involved in developing the program and putting it together, and then who subsequently should be involved in living with it and ensuring that data privacy compliance is brought to life within the company on an ongoing basis, even if people leave or change roles or whatever it might be, that all the knowledge and familiarity with the program doesn't leave with them. So in terms of development, you need several layers or levels involved in order to put together an effective compliance program. So essentially, if there's not management support and top level or executive level management support, then it's going to be difficult. It's going to be difficult in the sense of achieving consistency of the policies, achieving buy-in from people. Some of the policies will be essentially trying to regulate parts of the business and maybe stopping them doing things that they perhaps have done for a number of years, even if they shouldn't have been. And so having that top level commitment to the whole project is terribly important, particularly then if it's going to lead into questions about headcount or appointing new roles or whatever it might be. The management at the top need to be heavily involved. In terms of actually getting the work done, we find it most effective where organisations put together a fairly small group to act as the development group. It may be half a dozen or so, who are responsible for generating or writing the initial documentation and developing the program, and then also subsequently taking it round to a wider audience internally to make sure that the people who are going to be most impacted by the policy are comfortable with what it says. And so, because you also need to get their buy-in, rather than you need to avoid a situation where you develop something and you try and roll it out and it's the first that anybody has heard of it, and it seems to impact their business in a way that they're not terribly keen on. So what we tend to find is, for that wider team, having identified who the people who might be most affected are, whether it's HR or marketing or whomever it is, and doing so by country or geographically as well, it's enormously helpful for there to be some sort of very early on awareness training for the wider team. And the reason for that is because there's loads of terminology in this whole stuff. There's personal data, controllers, processors, data subjects, however you describe it, you find yourself using language that perhaps isn't obvious to people, or perhaps which is misunderstood. And so awareness training, we find, for the wider team, the people who ultimately will be asked to review and sign off these documents, is essential, so as partly to get their buy-in, but also partly to sensitize them to some of the issues and to get them looking and considering the documents in the right way. So I want to talk you through the whole process of how that works. That's just some suggestions of how we tend to pull it together. Top level commitment, small team to do the work, wider team to approve the work. Going forward though, it's very different. That handoff between the development team and the actual compliance team, the people who are going to live with the policy and manage it, that needs some careful thought, and it needs to be handled properly. And what we generally find is through a mixture of training and further education and support, it's usually possible for our clients to identify individuals within all of the essential functions. So that could be HR, it could be audit, legal, IT, data security, marketing. There could be, it will depend on the organisation concerned, but there ought to be somebody within each of those functions who is familiar with data privacy, who has an interest in it, who has some expertise in it, but also is part of the business. And I think that's quite important, because it means the people who are looking after, say, data privacy compliance of the marketing function, they also are marketers. And so they look at it the right way, they consider it in context and in a way that is relevant to their part of the business, rather than in some abstract data protection way. Now what we also see is, as well as those sort of subject matter experts being within the various functions throughout the organisation, we also increasingly see, whether they're called data protection officers or as we see fairly commonly, data protection champions or data privacy champions, those individuals who see compliance with data protection as a much more significant part of their role. They may be, for example, the first line of any question in a particular country or a particular region, depending on how the organisation is set up. So going back now to the question of developing the privacy program, one of the first decisions that needs to be made is, what is the scope of that program? And there's lots of ways of determining what the scope is. So for example, what level of compliance is it that the organisation is trying to achieve? So for a typical multinational that may be doing business in 100 countries, is it the intention of the program to try and achieve as near complete compliance in each of those 100 countries as possible? Or is it, as is far, far more commonly the case, the desire to essentially introduce a baseline? So to identify those compliance steps that are common from all of the different countries, in that example of 100 countries, and by generally improving compliance at a across the board level, to achieve a much greater level of local compliance in each country, albeit not to achieve complete compliance. So that's what we mean by the baseline. So everybody gets better everywhere, but there may still be a delta between the requirements as set out in the policy and the detail of local law. And what this means in policy terms is, essentially, everybody would develop that sort of baseline improvement in compliance across the board, but if the intention is to achieve full compliance everywhere, if that's even possible, then it would be necessary to spend a lot more time identifying the local legal requirements and that delta, country by country, between the local legal requirements and the baseline policy level. You'd have to do that in each country, and that obviously has implications in terms of time, cost, and several other things. The other consideration in terms of scope is, well, geographically, what are you trying to do? So is it just UK only, which is, we see that fairly infrequently these days. Most of the projects we see are either at least European, but usually global. So are you trying to improve the compliance of all of your European operations or all of your global operations? Now, what we tend to see on that is actually a bit of a hybrid. So the policy would be written so as to apply globally to the processing of all data from any country, wherever it is around the world, in any country where the company does business. The policies would apply and the program would apply. But often what we'll see is then but this is what I mean by hybrid, certain additional protection or perhaps additional legal rights being given in respect of data that may have come from Europe, for example. So even if that data is then being processed in the United States, insofar as it's EU data originally, then it may be that there are additional aspects of the policy that would apply to it. And then one of the other difficult questions that organisations sometimes face is that many of the laws, particularly around Europe, apply to manual records, that is paper records. It's not just things on computer. And so organisations right at the outset need to assess, are they going to attempt to cover that? And if they are, that may be a very good thing. But what one is facing then oftentimes is regulating organisations, subsidiaries, offices that may have boxes of paper in the corridor or untidy desks or whatever it might be. Bringing in the actual paper side of data protection can, to some extent, increase the compliance burden. Now, of course, it's already the law in those countries, so you kind of have to do it anyway. But query whether that's also a requirement that you would be keen to export to those countries that either don't have any data protection law at all, or if they do, that don't have data protection law that also applies to paper records. Just to finish off, I wanted to touch on a few of the bigger considerations that need to be thought through just before you start writing the policy, because this would influence very much how you, the tone of what you write, and also how you address some of the issues. So the first thing to think about is, well, what is the document you're trying to write? So it's a policy, and typically in a compliance context, that would be a document that sets out the do's and don'ts of handling personal data. In other words, its audience could be everybody in the company, or at least everybody in the company who handles personal data, and it would set out for them things they must do, like give notice, and things they must not do, like share data with third parties. So it sets out the rules, if you like. The other component of this is you have another audience, and that's maybe the same people, but as well as being individuals who handle personal data, the company, at least on the employment side, would also have individuals about whom personal data is being processed. So one of the choices to make at the outset is, are you going to write a policy that both sets out the rules, so what you have to do for data, but also gives notice, in other words, describes to readers what is being done to their data, and that's something that can be done in the same document? Or would you, as some organisations do, prefer to separate those out? So have a document that's clearly a policy and sets out the rules, and a separate document that informs employees and customers, or whomever it might be, in a slightly more user-friendly way perhaps, or more accessible way, what is being done with their data. So that's the first thing I'd suggest that is thought about. The other is, there's a lot of overlap, as you'll have picked up, between putting in place a compliance program but also implementing some of the data transfer solutions, such as safe harbor or binding corporate rules, for example. Depending on what your ultimate data transfer solution is, that can significantly impact the contents of the policy. So, for example, if the intention is to use the compliance program as a basis for a binding corporate rules approach, then it's terribly important that at the outset, the various checklists and, if you like, skeleton policy for BCRs issued by the Article 29 Working Party and available on their website, that's used as the starting point, because otherwise, starting without that would mean that you immediately open up perhaps more of a delta between your starting point and where you ultimately need to get your BCRs approved than you need to. And then finally, as a final thought, these documents that you're writing, they shouldn't exist in isolation. So simply preparing a policy and a bunch of guidelines or training materials or whatever it is, and just having them sloshing around there somewhere inside the organisation, while it may make one feel good for a while, having done the work, ultimately it won't be effective, because people won't be able to find it, they won't be aware of it, it will simply exist in isolation. And so the final thought I would suggest is just to think about how all of the good compliance work that's being done can be made to fit in within the existing governance structure within the company. So if the company has, as many do, an ethics code or whatever it might be, how does it form part of that governance structure? If the company, on other issues such as confidentiality or anti-bribery or whatever it might be, uses corporate directives or policies or whatever terminology may be used, then it's important that whatever data privacy compliance documents are developed are brought within that existing framework and subject to the same sort of overall controls and processes. I hope that's been helpful. That's, as I say, just really intended to summarize the main points. Thanks very much.